This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to speak about innocent co-insureds who find that their claims are denied because a co-insured had done something wrong, like presented a fraudulent claim or burned down a building intentionally. When denying a claim for fraud, it is necessary to determine if there are any innocent co-insureds, and if so, whether the innocent co-insured is entitled to any indemnity. The question whether arson by one co-insured spouse bars the innocent co-insured spouse from recovering under an insurance policy was one of first impression in Iowa in 1990 in a case called Vance versus Pekin Insurance Company. The Supreme Court of Iowa noted that courts across the United States have developed three distinct theories of recovery to resolve the question. Several years ago, one writer critically examined those theories and the rationale for them in an article entitled "The Problem of the Innocent Co-Insured Spouse," published in a law review. It is still the well-settled law in Iowa that the use of the words, quote, "any insured," is an unambiguous phrase that precludes coverage for all insureds, including an innocent co-insured spouse. If any insured sets fire to a house, all insureds, including the innocent co-insured spouse, are barred compensation, as stated in 1995 in Johnson versus Farm Bureau, an Iowa Supreme Court case where the court held that any insured resulted in denial of coverage to all insureds under the exclusion for bodily injury. The Iowa Supreme Court in Vance went so far as to encourage insurance companies to purge their fire insurance policies of ambiguity by replacing the exclusion language of "the insured" with "a, any, or an insured." Insurance companies were slow to follow the recommendation, while many adopted the suggested language. The three theories of recovery emanated from disagreements whether property or contract law should govern the interpretation of the policy. An innocent co-insured spouse may recover depending on whether co-insured's interests under the policy are joint and several. To resolve this question of interpretation, some courts have used property law principles, other courts have used contract law principles, so it is not surprising that the courts have reached conflicting results, even though the factual scenario in most cases is remarkably similar. Iowa decided to apply the terms of the contract and ruled against the purported innocent spouse. The Michigan Supreme Court has repeatedly held that a fire insurance policy that purports to deny coverage to an innocent co-insured is void as being contrary to the standard fire insurance policy language. The Michigan Court of Appeal explained that the statute did not expressly create a joint obligation of suretyship among the insureds and that it would be inappropriate to infer such a suretyship. Therefore, the court held that the statutory language voiding the policy in case of fraud by the insured must be read to bar only the claim of the insured who committed the fraud, and not that of an innocent co-insured. California was one of the last to join the trend in providing coverage to an innocent co-insured in Watts versus Farmers Insurance Exchange, a 2002 decision of the Court of Appeal. The Court of Appeal decided that Mr. Watts, a reportedly innocent spouse, was not precluded from obtaining any recovery because of his wife's misdeeds. Farmers initially convinced the trial court to refuse indemnity to Mr. Watts because of the ruling in a case called Val.U.L.Rev versus Fire Insurance Exchange, a 1968 California Court of Appeal decision. Val.U.L.Rev did not involve jointly held marital property. In Val.U.L.Rev, property belonging to a closely held corporation was destroyed in a fire, and an officer and shareholder, along with an ex-officer and ex-shareholder, were convicted of arson. The corporation sued the insurer. The trial court entered judgment in favor of the insurer based on the corporation being the alter ego of the two arsonists. On appeal, the corporation pointed out that the shareholder arsonist owned only 50% of the shares. His ex-wife and the other arsonist's ex-wife owned the other 52%. The two women were officers, and at least one of them took an active, full-time role in the operation of the corporation's business. Neither had a role in the arson. The Watts court, comparing Val.U.L.Rev to its facts, reported, quote, finding no dispositive California law on the issue of whether a corporation could recover from its insurer under these circumstances, the appellate court conducted a lengthy review of the law in other jurisdictions and concluded there could be no bright-line rule. From the cases decided in the other jurisdictions, the following basic rule may be deduced. The arsonist's status as an officer, stockholder, employee, or agent of an insured corporation does not necessarily preclude the corporation from recovering under the policy of insurance. The basic function of the court is to see that no one takes advantage of his own wrong. An analysis must be made in each case to see if the arsonist will benefit by the recovery of the policy either directly or indirectly. The court reversed the defense judgment and remanded the matter for findings on various factual matters, such as whether the arsonist shareholder was in dominant control of the corporation, whether the cash used to set up the corporation came from separate property of the wives, and whether the couples separated before or after the fire, close quote. The construction of insurance contracts has always been governed by the same rules of construction applicable to all contracts. Although they claim to follow the general rules of construction, Watts seems to apply a different rule. All contracts are interpreted equally except insurance contracts, which are interpreted to favor the insured. An insurer may not rely on an ambiguous interpretation of a policy provision that, if construed as the insurer contends, would deprive the insured of coverage. Nor should the insured rely on unambiguous, clear, and explicit interpretation if a court determines a public policy reason exists to change the contract terms. When the language of an insurance contract is reasonably susceptible to two constructions, it should be construed in favor of the insured, except when a public policy interferes. In its decision of the relevant authority, the Val.U.L.Rev Court summarized its understanding of the rules governing recoverability by an innocent co-insured in other types of situations and relationships important to Watts in any innocent spouse situation as follows, quote, mere family relationship of the arsonist, which does not bestow a property right or other direct financial benefit in the proceeds of insurance, does not bar a recovery. But if the property insured is community property, an innocent wife cannot recover if her husband willfully burned the property. Even a divorce prior to the fire without a division of the community property does not alter this rule as to property presumptively community. Even an innocent joint tenant has been denied recovery where the fire is set by the other joint tenant, close quote. The court in Val.U.L.Rev cited no California authority for the proposition set forth concerning community property and was stated to be dicta and not controlling. Val.U.L.Rev involved misfeasance by a corporate officer and shareholder and recovery of damage to corporate property. The statements concerning community property and joint tenancy merely represented a recitation of the recent authority in those areas from other jurisdictions. It also included understanding of California community property law. In California, any money earned during the pendency of a marriage and any property acquired during the pendency of a marriage are owned by the marital community. Therefore, if the innocent spouse is paid for the loss caused by the crime of the criminal spouse, the criminal spouse automatically owns half of the payment and profits from his or her wrong. The Watts Court, ignoring California community property law, concluded that the trend noted in Val.U.L.Rev has been reversed and currently favors permitting recovery by the innocent insured party up to his or her percentage share of the value of the property, unless the policy contains language which clearly excludes this possibility. Comparing earlier Wisconsin decisions with more modern decisions from other jurisdictions such as Michigan, Illinois, and New York, the court concluded that imputing the incendiary actions of an insured to the innocent insured and creating an absolute bar to recovery by the innocent insured produces inequitable results. The modern rule adopted by courts in other jurisdictions permitting recovery by innocent insureds preserves the essence of the legal principles recognized in the cases and produces an equitable result. The court, following what the Watts Court said, the modern rule, discard the conclusionary maxim and turn instead to the language of the policy to determine whether the rights of the insureds are joint and several. As a result, Mr. Watts was prevented from recovering, but Mrs. Watts was able to go to trial and attempt to recover from farmers. Interestingly enough, when the so-called innocent spouse in the Watts case was eventually tried, the fraud by the innocent spouse, so-called, was established, and neither the Watts spouses recovered anything from their jointly fraudulent claim. On the other hand, the Nebraska Supreme Court concluded that there is no public policy specifically articulated by Nebraska statutes or case law which would preclude application of the intentional acts exclusion to negate coverage against the peril of fire to an innocent co-insured under the uncontested facts presented A case called Val.U.L.Rev versus Hartford, a 2002 decision of the Supreme Court of Nebraska. Unlike Nebraska, the courts of the U.S., like the Watts Court, use the specter of public policy to dictate a rule that does damage to the clear and unambiguous language of the policy, stating that although a wrongdoer should not benefit from his wrongdoing, the public policy behind this modern trend requires that an innocent co-insured be permitted to recover based upon the insured's reasonable expectations. The modern rule benefits the public good by not punishing the innocent victim for the wrongs of another and preventing unjust enrichment by the insurance company. After consideration of competing policies, the courts have held that the more enlightened reasoning dictates that the illegal destruction of jointly owned property by one co-insured shall not bar recovery under an insurance policy by an innocent co-insured. The so-called enlightened reasoning required courts to ignore the words of the contract and replaced them with other words that allowed an insured to recover indemnity even if the insurer proved that an insured committed fraud. This video was adapted from my book, Zelma on Insurance Claims, Part 110, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found the video useful or interesting, please refer it to your colleagues. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.